SJC-13285, Commonwealth v. Charee R. Rainey.
Attorney McKenna.
Good afternoon. If it please the court, Gail McKenna for Mr. Rainey. There are three issues raised in this case. The first being whether or not it was proper to admit the illegal wiretap against the probationer in this case. I think this is a place where the statute is abundantly clear and that it is illegal to disseminate an illegal recording.
Why does your client have standing to assert the statute?
Well, you know, the interesting thing is in the statute it talks about standing and being an aggrieved party. And in terms of being an aggrieved party, that's to bring a civil action against whoever made the illegal recording.
Right, so the statute sets forth at least that remedy.
However,
it's not available to your client.
No, and I agree with that. However, I would contend that submitting illegally recorded evidence, which a statute specifically says cannot be disseminated, that the client would have standing to object to that, that it shouldn't have ever been admitted at all. It's just a clear violation of the law. It's just clearly illegal. And it impinges on the judicial process when we have something that is so highly protected to suddenly come into evidence. Whether counsel was ineffective in failing to object, or the court should have recognized it, or the government never should have offered it in the first place. It should never have come into evidence. So I would contend that it was simply completely illegal. It would be like...
Is it illegal for us to review the footage?
You know, that's a wonderful question.
Well, if you want, I'd like an answer to it.
I believe that...
Is that your client's position, that by viewing the footage, the SJC has subjected itself to fines and potential imprisonment?
Well, you know, I think you can decide the case without reviewing the recording. Here we know the judge below did review the recording. It's not impounded.
So you're saying the judge below is subject to fines and imprisonment? That was the legislative intent?
That's what the legislature said. And the reason that the legislature is so firm on some of these things is that Massachusetts has very stringent privacy laws. And here we're protecting the privacy of a homeowner from somebody coming in and recording.
She's invited the cops in to protect her, right?
She has, but
she's invited them to protect her. She wants, obviously, them to, you know, hear her story and act on it, take down what she's saying seriously. Is this really a secret intercept?
Yes, it is.
How can that be? This is basically a totally different situation than that. The police have been invited in. They're not secretly doing anything except for and he's announced one thing I can't figure out factually. He's said he's recording, but she may not have heard it, right? What is the record on the police officer's announcement of recording?
It's very late along in the tape where he's already taken the statement, he's already spoken to the little girl, and then he's over on another side of the apartment, and EMTs and other people have started to arrive, and at that point he says, really kind of surreptitiously, I'm recording. Now, this is a very simple...
How can you say that surreptitiously?
He
well, he
mumbled
didn't
it to
say
himself.
it loud enough for everyone to hear and nod. And at that point, it would have been too late anyway. He's already done the recording.
Speaking of surreptitiously, the one thing about the statute, it does require that secretly hearing, secretly recording, but here we've got the officer who is right there seeing it himself. So if you were right, would we just suppress the recording but let the officer's observations in?
No, because the judge didn't credit them. I mean, the Commonwealth gets one shot at this, and the judge relied specifically on the illegal recording. And I do want to get back to...
I mean, you know, your sisters out there and brothers normally are arguing, wow, we want to make sure the police are not, you know, lying to us. Well, what better way of showing that than to actually show exactly what they said because it's recorded?
But what is the simplest thing that one can do? May I record you?
Yeah,
So simple.
I understand that this may have violated the the BPS policy. That's because he doesn't say it right when he walks in, apparently. He should have. But that doesn't mean it's a secret intercept. It may mean it's a violation of BPS's, tell people you've turned on your recorder, right?
Well, and get permission. But I think that we have to look at the statute in terms of the case law. We've had cases like Blood that tie this into the Declaration of Rights and the privacy right, the constitutional right. We've had cases like, I believe it's Jackson, where somebody recorded a kidnapper, and that was excluded because it was illegal.
But it was a secret intercept.
Right.
All those cases, except for, I think it's, what is it, Hyde, the case where the one with the First Circuit reverses us.
Part, yeah.
Excuse me?
They reversed you in part.
Yeah, that's the only case that's not really an intercept case, right? The cases that are more like this are the booking case and the decision Justice Fecto wrote for the appeals court. Those are directly on point, right?
I'm sorry, which case?
The Ashley case.
Yeah, all I remember is Judge Fecto wrote the case for the appeals court. I can't remember. I think Justice Whelan gave you the citation.
Yeah,
It's Ashley.
Ashley. Oh, Ashley, right. Ashley, where the defendant was recorded while he's being interrogated.
Right.
I mean, the point of the matter here is that coming into someone's home, recording them without telling them, whether they're a victim, whether they've invited you in, there's just no constitutional right or statutory right that allows somebody to record you in those circumstances. And the solution is very simple, and that's to ask permission. I mean, it's not as though that, if this court rules that this in particular was an illegal recording, that it's going to subvert all of the good things that have been done with body cams. All it means is that when you go in someone's house and you're talking to them, you have to tell them that you've recorded them. People don't expect anyone to come in their house and start recording them, even police. I mean, it's just a pure violation of the statute.
And obviously, you want them taking notes. You want them taking notes of everything you said, right? You want them to accurately get it down.
Well, the question here isn't about accuracy or not accuracy. The question here is that we have a statute that also under Blood and the Declaration of Rights has been shown to have privacy implications, and that the statute is entitled to be enforced. I mean, this is pure and simple, a surreptitious, illegal recording that then was presented in court without anyone sort of alerting to the fact that the dissemination of this is completely against the statute. Now, there may be better policies out there, but those policy determinations on whether or not the statute should apply to body cameras is best left for the legislature, and
What do we do with the fact that the legislature has told us why it's passing the wiretap statute in the written preamble? That is
Correct.
To allow law enforcement to use these tools for purposes of investigating organized crime, and at the same time prevent private individuals from using these intercepting devices for their own private purposes. And that's actually built into the statute. So it's not
Right.
legislative history, it's the written terms of the statute. And then, you're trying to read the criminal aspects, or the sort of the civil fines, criminal aspects in isolation, right? But here we have a statute that in writing says, these are our purposes. In light of these purposes, we're going to preclude secret recording of oral communication.
Except that the statute goes on to say that the only two times that police can do a recording like this is with a warrant, with judicial authority, and in very limited one-party consent situations, which involve, say, an exigency where somebody who's undercover is in danger. That's specifically in the statute. And that's what this court has enforced throughout the history of the act, which is Those two things have to happen. And in the instance where there is a warrant and the Commonwealth is going to present at a trial this type of evidence, that the statute lays out what the Commonwealth needs to do to even use this at trial. And that starts with they have to send it to the defendant gets to look at it, and then the defendant has a right under the statute to suppress, which includes suppressing based on the lack of a warrant.
Yeah, and that
So-
brings me back to the standing issue. It's like the statute itself has at least two remedies. One's a civil remedy, which we've discussed before, and then there's the motion to suppress in a criminal trial. Why do you think the statute also applies to probation revocation? What in the statute, given that it does have these two remedies, gives your client the remedy of precluding its use in connection with a probation revocation proceeding?
It's completely and thoroughly forbidden. That's
So
it.
your review of this videotape would subject you to criminal fines and potentially 2 years in the House of Correction.
Would. It would. I mean, I didn't alert on the issue until I got into the case, and I'd already watched the video, but you know, that's one of the scary things about dealing with this, and that's why,
You think that's what the legislature intended?
yes, I do.
That you would be subject to civil fines and possible imprisonment?
I do.
Okay.
Counsel, I need to go back to Justice Kafker's earlier point because my memories, I just disagree with you on this. Assume for the sake of argument that it does apply to a probation revocation hearing and say the judge in this case should not have relied on the tape. The judge, if I remember correctly, very distinctly made findings based on Hartfield on the record that he credited the testimony of the officer as to what the officer said about what the mother said and what the daughter said. He testified to what they said to him about it was a verbal altercation, it turned physical, and I asked the daughter to call the police, and the phone was knocked out of her hand. All of those things the judge said he credited based on the Hartfield factors. So even if the recording itself were not proper to be reviewed, why couldn't the revocation be based on the testimony of the same thing?
My memory is that he didn't mention the officer's testimony, and that when he made his findings, he relied specifically on the tape and what he had
When he was
observed and watched
recounting
on
the
the tape.
Hartfield factors, then what was he going to? The
tape.
hearsay of the tape?
Correct, the hearsay of the tape. And so, you know, speaking about hearsay and the admission of hearsay at hearings like this, I would suggest to you that the Hartfield factors are so broad that they virtually let anything at all in, and that they themselves don't result in substantially reliable evidence being before the court to make an accurate determination. And I did suggest in my brief, as I will now too, that the rules of evidence ought to apply. There's no way that this would have been admitted anywhere had the rules of evidence been applied. And I think that there's been changes in the law that sort of we should be moving with. You know, Crawford, Melendez-Diaz, cases that talk about viewing evidence in different ways. And I would suggest to the court that the Hartfield factors just aren't a measure of reliability. The measure of reliability that we have here in the Commonwealth are the time-tested rules of evidence that we apply all the time. The other problem is that if a defendant doesn't really have notice of what Hartfield factors are out there or what evidence is going to come in, does he really have a due process notice of what the evidence will be against him? Because that determination is only made at the end when the judge makes a determination whether or not it was substantially reliable. I also make an argument in the brief about suppression in hearings like this, and I would just say briefly, because I see my time is running out, that, you know, unfortunately, because the probation surrender comes first, unlike in Morrissey v. Brewer or Durling, if someone is found to be in violation of their probation, they're then sentenced. And so that drives the result in the criminal case where then there's pressure to plea out in order to get concurrent time. So in effect, the illegality of evidence or collection of evidence never gets tested at all in the Commonwealth. And it is just more fair to allow suppression in these types of, in a probation surrender. And that happened in Morrissey v. Brewer, which the court found that there was a questionable confession, and that was part of the driving force in Morrissey v. Brewer. So unless there's any other questions, thank you all for your kind attention and for rescheduling for me. I'm very appreciative, and I would otherwise rest on the papers.
Thank you, Ms. McKenna. Ray Hartley.
Good morning, and may it please the court. Brooke Hartley for the Commonwealth. This court should affirm the revocation of the defendant's probation for 3 reasons. First, the wiretap statute does not apply to a police officer using a body-worn camera responding to a domestic violence call. Second, even if the wiretap statute did apply here, the recording would be admissible at a probation revocation hearing. And third, even if the body-worn camera was excluded in this case, revocation was still proper because I disagree with my sister. The judge did credit the officer's testimony, and that was sufficient here. Unless the court has specific questions, I'll start with the wiretap issue, which my sister seemed to focus on. So the purpose of the statute is to allow police to investigate organized crime with technology, but to generally protect this very narrow privacy right, which is a private right to private communications. And the statute was not intended to protect conversations that were not meant to be private.
How about our Hyde case? Is Hyde the case where somebody records the police?
The police officer, yes.
It seems it's a little out of your sort of core that you just described, isn't it? I just can't tell. Was that just wrong, Hyde? Was our case
So
wrong?
I think the exception, you mean Hyde was ultimately reversed?
Well, Hyde's reversed on other grounds, but First Amendment grounds. But is Hyde a misinterpretation of what an intercept is?
No, I don't think so. So an interception, the critical question in determining whether there was interception is whether there was a surreptitious recording. And that's what this court discussed in Gordon and what the appeals court in the context of
Was Hyde surreptitious or not? I just don't remember.
Yes, it was.
How was it surreptitious?
He was secretly recording on his phone. And I think in Hyde, the court said it would have been a different case if, for example, he was holding his phone out or it was clear that he was using a recording device. But it wasn't in Hyde. So it was, in fact, a surreptitious recording.
That's the key element here. That has
yes, yes. And
why is it not secret here? Because he doesn't tell her that he's recording, and I guess these things don't light up. So why is this not secret, I guess?
well, so first of all, I would just point out that I think this is a very difficult case to even reach this issue on. The court doesn't need to reach the wiretap issue, but it's a very difficult case to reach.
No, if it's illegal to do this, and it's a key component of what the judge relies on, which it is, you're in trouble.
Well,
Doesn't the exclusionary rule, it doesn't apply in probation?
it doesn't apply. That's where I was going with that. But even still, I would just note that it's difficult because this wasn't raised below. So we don't have anything in the record below about notice. Now, the
Don't know
Commonwealth.
if it was like this big or where.
Correct. We don't know if there was a red light on. We don't know, for instance, if the other officer came in before and said, my officer's coming behind me, he's going to be recording you. There was nothing in the record. No one was asked about notice. But of course, the Commonwealth's position is that notice wasn't required here because it wasn't a surreptitious recording.
Again, just help me out here, because I agree with you. This isn't what the legislature intended, but I don't quite know why this isn't secret based on this record. That's because she wasn't. How do we get over that here? I mean,
so I think Gordon is instructive, or excuse me, I think Gordon is instructive, but also Ashley is instructive here. And there, the court found that the statute was not violated by a recording of a police interrogation, despite the fact that the judge found that the defendant did not know that he was.
Be the same as the civilian in Hyde holding up his phone.
right? If we said that the civilian holding up his phone wasn't surreptitious, this is a recording out in the open.
Certainly, I think that's a possibility, but again, I think we just don't have the facts from the hearing because it wasn't raised below. So we don't have anything from the victim about whether she saw the camera or how big it was or anything like that. But it's certainly very possible that it was obvious. And notice isn't an issue even if the wiretap statute were implicated.
Which way does that cut? The fact that the record is devoid of any information from which we can garner whether or not the victim knew that she was being recorded?
So in this case, I think we can speak in generalities about it without having that information because, again, because this was not intended to be a private conversation and therefore was not a surreptitious recording. I don't think we even need to talk about notice. And I would also...
But the statute applies to secret hearing and also secret recording, both.
Correct.
So if the record is devoid from any information from which we can garner whether or not she knew she was being recorded, literally under the terms of the statute, if we read it literally, it violated the statute.
I'm not sure that's true because of the way this court and Ashley have interpreted that language about what an interception is.
Well,
So
it was, if she didn't know she was being recorded, it's almost by definition a surreptitious recording.
no, I think I would disagree with that, Your Honor.
Explain that.
Yeah, so the statute prohibits an interception, and under B4, that is defined as, like Your Honor said, to secretly hear or secretly record through an intercepting device by any person other than the person given prior authority. And so this court and the appeals court have interpreted this language to specifically refer to a surreptitious eavesdropping. So even if she didn't have notice, that doesn't necessarily mean that it was a surreptitious eavesdropping. Because a surreptitious eavesdropping would need to be a secret recording of a conversation that was intended to be private.
You're just
So-
saying that the secret recording, you're analyzing the person recording, not the person who's being recorded.
Yes, I think that's right, Your Honor.
I think if we can go just back to just Wendland's question, though, when the record is devoid of that, who does that help and hurt? Because one way to look at it would be that the foundation wasn't laid to put in the recording. Another way to look at it would be there was no objection based on the lack of foundation. So who has that burden of production?
So again, because it's a probation revocation hearing, I'm not sure that would be an issue here.
No, obviously, if there's no suppression, even if it was illegal, you don't have to worry about a question like this.
Okay.
But well, maybe you do, because the question is what's the foundation required to put it in? Can probation just put in the recording, and if the probationer objects, they have to raise the objection? Or is it part of the requirement to put in the recording that you've satisfied that it's not secretly recorded and secretly heard?
I think probation can just put in the recording. I don't think it's necessary to satisfy that element where the wiretap statute isn't implicated at all.
But so let's deal with the case that's really close, which is Jackson,
Sure.
right? The defendant in that case was recorded, and this court, not the appeals court, this court held that the secret recording violated the wiretap statute. Now, the evidence ultimately came in because the defendants had said, I know you're recording this. But here we don't have the victim saying, I know you're recording this.
So, and in Jackson, that was a different situation because it was a phone call being recorded.
Yeah.
And it was a surreptitious recording. This is a case where you have the victim who called the police, who invited the officer into her home.
Just to stop you there, so here, in that case, the defendant called the ransom, so there's the same, right?
So
The victim called here, and in Jackson, the defendant called the phone.
Correct. I think the distinction there is that the victim called the police, and she called the police to report a crime, and she called the police to give them information to help them in an investigation that presumably is going to be memorialized in a police report and used in the investigation of this defendant.
Does the word interception help you? I mean, again, I have two football players here, but usually you're intercepting something directed to somebody else. Right? This is talking directly to you. I'm just wondering, is the word interception add another element to this that we should be focusing in on, which is you're getting in between a communication between two.
I'm not sure, if you look at Jackson, I'm not sure that holds true because the person recording is the person receiving the information. So I think, again, I sound like a broken record, but the critical question is whether it was surreptitious.
I'm a bit confused. So if the police went in there and suppose the police officer had an old-fashioned bug, which is what this statute started out as, hidden in his clothing, and he recorded the person making the complaint, is it your position that it wouldn't be a surreptitious interception? Because it's a complaint to a police officer. That's your bottom line.
Yes, that's
Where's
true.
that in the statute?
I'm sorry, Your Honor.
Where is that in the statute?
So I think that falls under the definition of interception, which is it's not a surreptitious recording, because this is a person giving information to a police officer she does not intend for this police officer to keep it private or for this conversation to be kept private. Now, it might be a different situation if the police officer came to the door and was waiting outside and turned on his body camera and started recording a conversation she was having in the home. I think that would be a surreptitious recording, but that's very different than what we have here.
You invite somebody to your home, you expect them to record you? The police?
Well, she was speaking to him and she was giving him information. So I think this is completely separate and apart from a Fourth Amendment reasonable expectation of privacy analysis. We know.
But you're limiting the wiretap statute, at least your reading of it, to that Fourth Amendment reasonable expectation of privacy.
No, Your Honor. No,
I
Your
thought
Honor.
that was your point, that she invited the police to her home to report to the police what had happened to her.
No, I don't think that's true. I think there are certainly situations where an individual would have a reasonable expectation of privacy, and there would be a violation of the wiretap statute and vice versa. And I think that's very obvious from this court's decisions.
I don't have the statute in front of me. Do the words private conversation appear in the statute?
No, Your Honor. That is taken from this court and the Massachusetts Appeals Court's interpretation of the meaning of interception. And that's Gordon and that's Ashley. So those words are not in the statute, no.
But both of those cases are not about the meaning of interception. Both of those cases are about, we don't think the legislature intended this.
Yeah, it's a book and photo. It's the book and room, and it's a.
So I think it is
not
about
about interpreting the language of the statute. They're saying, in the context, literally the statute could read on this, but we're not going to. The legislature's got more common sense than that. That might be your strongest argument, not.
I think those
literal
two
words of the
things are
statute.
related. I think that's absolutely true, that this is not what the legislature was intending to protect. And I do think that those cases, Ashley and Gordon, do talk about the meaning of interception.
And they say, plainly, if you just read the words,
yes,
they're
a
included.
technical application of the statute might yield different results, but
Right.
that could not have been the legislature's intent.
right. And so that's why I'm suggesting that might be your strongest argument. It's that the legislature unless the legislature tells us we intend your co-counsel to be subject to fines and criminal penalties in the House of Correction, we're not going to assume that this language means what it literally means.
I think that's true. And again, I think that's because of what interception means, but what the court has interpreted interception to mean.
So
But
if the person who annoys me on the commuter rail speaks on a cell phone, right? And I take out my cell phone, I start recording that person, that's not a wiretap violation because the person's blabbing in the public?
so I think So again, I think we have to separate the reasonable expectation of privacy
Nope,
and,
we're going statutory language.
yes. So I think that it's possible that it would be a violation of the wiretap statute if it's, well, actually, I take that back. I think the person is not intending that speech to be kept private if they're blabbing right next to you on a train full of other people.
They record.
Yes, so I think if this happened somewhere else, it's possible, if two people were having a conversation on the street and
So
there
if
was.
two people in front of me in the commuter rail are having a quiet conversation and I take my cell phone out and I record them because I'm a creep, is that a interception?
I think we would have to look carefully at the facts there, but I think it's possible that it would be an interception if that was a conversation intended to be kept private.
Right. I don't get this distinction, but we'll figure it out.
If the court has further questions on the wiretap statute, I'm happy to answer. Otherwise, I see that I'm out of time. Would the court like me to briefly address the other two
I think we're all set.
points?
Yeah.
Okay,